Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Michael Desmarais. Michael is an attorney. His office is in Los Gatos in Silicon Valley, here in California. Michael is an estate litigation attorney. That's the bulk of his practice. He also does estate planning and some estate administration work. I've known him for a number of years, and so he's a great guest. I know that you're going to enjoy this interview. Michael's he's just well known here in Silicon Valley. For example, we have a meeting of our Silicon Valley Bar Association here in December where we do an update. And so we have three of the leading attorneys, one of which is Michael. And so we have, I don't know, it seems like 1,000 attorneys out there in the audience, all coming to hear what they have to say. And Michael always has some wonderful information to share. So today, Michael and I are going to be talking about your rights as a beneficiary. Now, as we get started, I'm going to caution our viewers that we want you to get your own independent legal counsel. We're not going to answer all of your questions here. Also, California law. Michael is a California attorney. He principally works in lawsuits involving estates and trusts here in California. And beneficiary rights can be different in other states. And I'm a CPA again, I work here in California, so that's what most of my familiarity is. The state laws can vary as far as your rights are concerned, so you do need to get an attorney that's familiar with your state. Mike, thanks for joining me here today.
Thank you for having me, Mike.
Okay. All right, Mike, a close relative died. How can I find out if I have an inheritance?
Well, it depends upon what kind of property you may have inherited. But generally speaking, within 30 days after someone dies, the one who has physical possession of their original will is supposed to lodge it with the Superior Court of the county in which he resided. Mm-hmm. Lodging doesn't mean they have to actually start the probate process, but they're supposed to take the original and give it to the court clerk. Mm-hmm. And the court clerk files that under a system where you can go down to the county courthouse, give them the name of the person you think has passed away, and they'll look it up to see if they've got the original will. If there was, say, a trust involved, the way you find out about that is that the named trustee, the one that takes over control of the property, afterwards is supposed to send you a notification within, I believe it's 30 days after the settlor, the one who set it up, dies, mm-hmm. to inform you that they have died, and if you want a copy of the trust, you may get one. Now, some people have money that's in the bank in what are called either joint tenancy accounts or taught trust accounts, which don't have to go through probate. Mm-hmm. For those, it's actually more difficult because unless you can find out where their banks are, it's hard to find out if you've inherited anything from them. Mm-hmm. Of course, the mail that comes into that person's house monthly would normally include things like a statement for the joint tenancy account or the taught trust account or the pay on death account, and you'd find out about them that way. So there's a variety of ways in which you can find out if you've inherited anything, but those are the major ones.
Yeah. You know, something that you pointed out related to that, the paper statement that's coming in. Of course, now more people are doing things on the internet, and so they're getting electronic statements, and I would think that would make it a little harder for the family. I talked to one family that said, we don't even know where his investment accounts are.
That's a very, very good point. I mean, if you have signed up with your bank for email statements alone, you won't be getting a hard copy of anything, and it might become more difficult. The bottom line, though, is pretty much this. The reason you'd probably get notice eventually mm-hmm. is that in order for somebody to take title mm-hmm. to the property of the decedent, they have to go through some process to gain that property.
Right.
For example, if the decedent's home is going to be in the decedent's name, mm-hmm. or in the name of the decedent as the trustee of his trust. In order for that person to change that title into their name, mm-hmm. or to the name of the person that's supposed to get it, they've either got to probate the will, in which case they've got to give you notice of what's going on through the mail, you get it in the mail, or they have to notify you about the trust because that's what the law requires them to do.
Right.
Now, I suppose it's possible that if somebody was the successor trustee of a trust, let's say that was John Doe,
Yes.
and the beneficiary was Michael Gray, John Doe as the trustee would have the power, not the right, to just sign a deed as the successor trustee, giving it to himself, and never even tell you about it. But eventually, if you found the trust and you could prove that you are the Mike Gray referred to in the trust document, you could sue John Doe to get that property back.
Yeah.
Living trusts, although they were supposed to be a cure-all for everything because people were concerned about things like probate fees, are really subject to a lot of abuse. And a lot of people that become the successor trustees, I don't think they want to intentionally steal it, but some of them think that I was made the trustee so I didn't have to get involved with all these legal things, and they go ahead and do things with the property because they've got the power to do so,
Yes.
even though they're not supposed to.
Right.
And then when they don't do what they're supposed to and they get sued, that's usually where I come into play.
Right. Well, keeps you busy. All right. My single mother died a year ago, and I believe that my brother is her trustee, and I haven't heard or seen anything happen for administration of her trust. What can I do to get things moving? And what if my mother remarried and my stepfather is the trustee?
That's a very good question and a very reasonable one. You know, you don't really want to be poking around at the funeral asking your stepdad what happened to mom's money, or your brother asking him that question, although some people do. Obviously, you would talk to them at an appropriate time, but if they just didn't say anything to you, people just say, I don't know, or I'm not going to talk to you, then you have a couple of remedies. If you know there was a trust, and for example, if you've got a copy of it, you can go to a lawyer and file a petition with the court saying, I believe that this trust exists, and I'm a beneficiary of it. Now, this other person is named as the successor trustee, the one who's supposed to carry it out, but he's not doing anything. He hasn't sent me a notification of death. He hasn't sent me a copy of the latest trust document, so I want the court to appoint me as the successor trustee. You give notice to that other person, I guarantee you they'll come into court, and then the judge will tell them what's there. Or, for example, if you don't have a copy of the trust,
Yes.
you think there might be one or there might have been a will, but you're not sure, then what you can do is you can go to a lawyer and you can start a probate. You can file a petition for what are called letters of administration, saying, I believe that my mother died without a will or a trust. It's called dying intestate. And I want to be the administrator of her estate to find out what should be done with her money. Because under the laws, community property law, a certain amount goes to her husband. Under the separate property law, a certain amount goes to me. And you give notice to the second husband or the brother, I guarantee you they'll come into court and tell you what's going on.
Yeah.
So you just have to start the ball rolling yourself. You may not become the administrator, you may not become the trustee, but you'll at least be able to find out what's going on with the money.
Yeah. Okay, good. Now, I'm a beneficiary of a will or a trust, and it has a no contest clause. Does that mean that I'm shut out or I can't challenge that will or trust? What should I do?
Well, it depends. They've changed the law with respect to no contest clauses to tighten them up. But a no contest clause says this: if you contest the will or the trust and you lose, you get nothing. Well, if the trust or the will didn't leave you anything to begin with, you don't have anything to lose. It's only where you find out that the will or the trust gave you, let's say, $100,000, and it gave your brother $900,000, and you kind of think that's unfair, and it may well be. Then if you contest that trust or that will, the grounds for contesting it are really very limited. One, that your mother or father was mentally incompetent or lacked what's called testamentary capacity, or two, they were unduly influenced, or they were coerced or defrauded. If you can prove one of those things, then you might be able to set that will or trust aside, and then under the laws of intestate succession, it'd go half to you and half to your brother. But if you lose, then not only do you not get the extra $400,000, you don't get the $100,000. That's what a no contest clause does. But it's not designed, and it's not supposed to, and frankly they don't anymore, prevent you from finding out where's the property, what it's worth, and when am I going to be getting it.
Okay. As a surviving spouse or a child of a decedent, what rights do I have, irrespective of the terms of a decedent's will or trust?
Well, if there's no trust, if there's just a will, and you're either the surviving spouse or a minor child, you're entitled to what's called a family allowance during the period of probate. It's kind of like spousal or child support, except it's what you get after they die until the probate process is over. It could be as much as a year. Sometimes if you've had a long marriage, you can get what's called a probate homestead, which is the right to live in the house for a period of years set by the court. If it's a long-term marriage, the surviving spouse might get to live in the house for the rest of her life. If, let's say, the estate consists of community property, that is, income that was made or earned during the deceased spouse's life and the surviving spouse's, well, the surviving spouse has got her half of the community property. Let's say the whole estate's worth $1 million and it's all community property, then $500,000 of that is hers. She doesn't have to wait for probate on that. She can petition the court right away, say, I want that community property to be set aside to me quickly. She may have separate property, which she allowed her husband to manage. That's hers as well. So you do have rights independent of what the decedent's will or trust says. In the old cases, sometimes the husband would put the wife to what's called a forced widow's election.
Right.
I'll leave you this so long as you do that. But they're very seldom used anymore. Any man that's been married for more than 10 or 20 years knows he can't coerce his wife into anything, not easily anyway, and so they don't try it anymore.
Okay.
But basically your rights to your own property are, even though it was mixed in with the decedent's property, are still yours to do with as you please and to get it if the husband doesn't leave you his half of the estate.
Okay. What if I take the executor or the trustee to court? Can I recover my legal fees?
Well, yes and no. It's a typical lawyer's answer. In the United States, we have what's called the American rule. In England, they have what's called the English rule.
All right.
And under the English rule, if you lose, you've got to pay the other guy's attorney's fees. Here, over there, they call them costs. Now, in America, generally speaking, everybody pays their own attorney's fees, win or lose. I could win a lawsuit against you for $1 gazillion, but you don't have to pay my attorney's fees. That's the general rule. It's called the American rule. To a certain extent, it applies in probate too, but there are some exceptions. One of which is basically there are provisions in the probate code which say this: if you were the executor and you didn't file an inventory and tell people what was there at the beginning of the decedent's death, what it was worth, or you didn't do an accounting of what came in and what you paid out, what's left now, or you did an accounting that was wrong, false, sometimes the courts will order you to pay the other person's attorney's fees for having to contest that accounting. Now, there's also a doctrine called the common fund rule, which works this way. Let's say, Mike, you had 3 children, and I was one of them, and Mom died, and she left her half to the 3 of us. Actually, she left it to all 4 of us, husband and the 3 kids.
Okay.
So you get a quarter, I get a quarter, and each of my 2 brothers get a quarter. But because you're a grouchy guy, you just wouldn't give us our quarter. You didn't like the way we were living our lifestyle. And I had to go into court to get you removed as the executor and have somebody put in place that would do what was supposed to be done under Mom's will. Now, if my other 2 brothers, or even just one of them, didn't have a lawyer, then whatever attorney's fees I had to pay get reimbursed out of the estate and charged to all 4 of us. So I don't get all of my attorney's fees paid back, but I get 3/4 of them. The theory being that my 2 brothers benefited from the work that I did getting you removed and getting somebody in, so they should shoulder part of the burden, as should you, because you made me go through that process.
Right.
But generally,